Now, we're talking about the legality of Hannatu Musawa's appointment, and we have joining us a lawyer who goes by the name Norison Quakers. He's a senior advocate of Nigeria. Thank you so much for joining us here on Newsday. Well, Norison, I hope that you can hear me, but I'll just ask you the first question. Some critics are saying that Hannatu should be relieved of her ministerial positions and saying she can hold both, while those who are supporting her are challenging anyone to produce the law that she might have breached on her NYSC status as a serving minister. I'm wondering which you think is more valid or holds more water on both sides.
Well, thank you so much. I would rather go with the second view or the second position in relation to the analysis that you've just given to me. Now, on my part, I'll be honest with you, I have not seen any constitutional infraction or any statute that the appointed minister has breached. First and foremost, we must first look at the constitutional provision as regards the appointment of a minister pursuant to the powers conferred on the president in appointing a minister. Now, Section 147 of the 1999 Constitution as amended vests power in the president to appoint a minister of the Federal Republic of Nigeria. And now the qualification for appointment of a minister, you have recourse to look at Section 147, sub 5. Incidentally, I also have the Constitution right in front of me. Now, it reads, no person shall be appointed as a minister of the government of the Federation unless he is qualified for election as a member of the House of Representatives. Now, that is the provision as regards who can be appointed as a minister. The person must qualify as a member of the House of Representatives. In other words, one who would likely be in a position to seek elective office into the House of Representatives. Now, when you flip all the way to Section 65 of the 1999 Constitution as regards the qualification to run for election as a member of the House of Representatives, it includes but is not limited to the fact that, one, you must be a citizen. Two, you must have attained the age limit as provided for in the Constitution. The minimum age there is 25 years. And three, you must be educated up to school certificate level, right? And then you also must be a member of a political party. When you apply all of these to the Honorable Minister, right, if she's short of all of these, and then he now raises questions as regards our suitability or our qualification. But as regards National Youth Service, because that is where the whole thing is anchored, and to be candid with you, I do not see any infraction. Provisions of Section 2 of the National Youth Service Corps Act makes it mandatory for every Nigerian graduate, right, to go in for national service and be given a certificate of service in that regard. Now, Sub 2 has provision as regards exemption. Certain categories of persons are exempted from service. Now, when you combine subsection 2 with Section 17, so you have categories of persons that are exempted from service and those who can defer their service year. You can actually defer your service year. But the significant thing is the criminality aspect, which you will find in Section 13 of the National Youth Service Corps Act. Anyone who is called off for service, who refuses to serve or who does not serve, if you're within the age bracket of 30, because the maximum age for youth service is 30. So anyone who is above 30 does not necessarily have to serve. If you served in the military, you're also exempted. If you're a national officer involved in the security architecture of the country, you're also exempted. But insofar as you are a Nigerian graduate within the age bracket of 30, you're mandated to serve. And that is the essence of Section 2, sub 1. Now, when you look at Section 13 that criminalizes the failure to serve, right? If you fail to serve, you could either go to prison for 12 months, and then the ridiculous fine you pay is 2,000 naira. The act has not been amended. So as far as I'm concerned, the Honorable Minister has breached no law because her appointer is actually the president, and then she was also subjected to screening. Now, she's undergoing service, but the question is she within the age bracket for service? If she's not within the age bracket for service, it means she ought to have been exempted. If she sought for extension of her service year, it means she deferred her service year to the current year of service. Is she within the ambit of the law to have done that? The answer to that is yes, because at the time she was within the age bracket of service, she ought to have served, and for some reason maybe she was not able to serve. Now, by the provisions of Section 17, she can actually seek deferment, subject to the approval of the National Youth Service Corps Council or the National Youth Service Corps Directorate. And so, as far as I'm concerned, I haven't seen any constitutional breach. But there's a significant provision in the National Youth Service Corps Act that a lot of people haven't really addressed in discussing this issue. Now, every employer is mandated or obligated to request for a certificate from either a certificate of discharge or a certificate in proof that the employee has served, has carried out the mandatory national service. So in other words, you must show your certificate of service issued to you by the directorate. And so for me, I don't think she has breached any law.
Okay, thank you so much for setting the tone of the conversation. But given that Minister Musawa's case is not the first instance of a serving NYSC member being appointed to a government position, in 2019 we saw the same thing happen with Kwara State Governor Abdulrahman Abdulrazak, where he nominated and eventually appointed then 26-year-old Joanna Kolo, who was still undergoing the one-year compulsory NYSC program in Jigawa State as Commissioner for Youth and Sports. Now, are there any legal precedents or established practices that can guide the resolution of this situation and provide clarity on the intersection of serving in government roles and fulfilling NYSC obligations?
Regrettably, I haven't come across any decision in that regard. The ones you find oftentimes are to the effect that when you want to run for elective office in Nigeria, part of the requirements of documents that you need to put forward is your National Youth Service certificate. Now, oftentimes, you look at I'm aware that the current governor of Enugu State is having issues in that regard at the Election Petition Tribunal. So because it's sub judice, I won't go into that. So you have a number of instances where these issues are being challenged. You remember Kemi Adeosun, I think the former Minister for Finance, on the issue of whether she served or she didn't serve. So it became an embarrassment to the government, and she did the honorable thing by resigning her appointment, and she walked away. But by and large, youth service is compulsory by virtue of the provisions of the National Youth Service Corps Act, Section 2. But in relation to Hanatu, it's not that she's not serving. It's not that she has come forward without a certificate. The fact is she's currently serving. So taking a cue from the one that was done by the governor of Kwara State is in line with what the law says. You cannot, as we say in law, create an obligation where there is no legal provision for that purpose. And so there's actually no case. And I don't think there will be any case in that regard. I just read the provisions of the Constitution to you in terms of requirement for appointment as a minister, and that you must be in a position to run for elective office into the House of Representatives. And the qualification provisions are there. It's only when you have flouted the qualification provisions that you will then be limited or inhibited from seeking elective office or being appointed as an honorable minister of the Federal Republic. I think we should spend more time in discussing matters that are of weighty consideration than this issue. For instance, is it right for the president to have appointed 45 ministers? What does the constitutional limit say? Those are the issues I think we should discuss as a people and then as a nation, and then properly guide both our National Assembly and also the executive. So for me, there's no law, there's no decided authority or case on this issue, except the fact that, okay, you must serve, which is basic, as is provided for under Section 2 of the National Youth Service Corps Act.
Well, duly noted, Mr. Quakers, but as we round up with you, I'd like you to set aside your, legal hat for a moment. And when we look at the average Nigerian that might have been, preparing to serve and looks at what has played out with Hanatu and what also happened in 2019, and they might decide to play the Hanatu card, what message does this send to Nigerians that are actually taking the youth service seriously, seeing as, there's no case like you mentioned?
Like I said, service is compulsory. Now, permit me to refer to Section 12 of the National Youth Service Corps Act, and it's very apt. There is an obligation on an employer of labor, right, in the private and also in the public sector, except where someone is being called up to serve. Now, in relation to Hanatu and the commissioner that you referred to in Kwara State, it is a call to service. Who is to request for the certificate of service? It is the employer. Now, if we see the appointment as employment, it then means that the president is under a duty to request for either a discharge certificate or certificate of service from Hanatu or any other minister, as the case may be. And I don't think this should be a precedent that will encourage anyone from service. Now, if you fail to serve, clearly there's something you call a penal sanction, and I earlier referred to that particular provision of the Act, and that's Section 13. You either go to prison for 12 months or you pay a fine of 2,000 naira or both. So the law is not an orphan. The law is very clear. And in doing all of this, for me, it also encourages those who want to serve in government to serve and not see the aspect of service as a barrier to discourage them from serving. The only snag that you might likely have not to seek even elective office is where you do not qualify under the law. Many of us served. At least I served in Katsina State many years ago in Malufashi Local Government Secretariat. And there are many people like me who also serve. And I do not see anything wrong in service. I mean, it's a period of integration and interaction. And many of the people I served with were still friends till tomorrow. And we're still well connected. And we're all around the country, and some are even abroad. So service time is a time to also give back to the society, even though the requirement for service is not also being fully implemented. But I will encourage as many people as are due to serve to serve. Are you aware that those who hold NDE are also allowed to serve? But you can see that some people have also been ostracized, or some have been hindered or barred from service, technically speaking. But everyone who has gone to school or a graduate in Nigeria, even outside Nigeria, you're encouraged to serve. It's good to serve. And I will encourage as many people as have graduated, if you're within the age bracket of 30, you must serve. And that's why it is mandatory. It's a mandatory provision. We're not talking of someone who is not serving, someone who is currently serving. And I don't think it should be an issue, as far as I'm concerned. Those are my own thoughts.
Thank you so much, Senior Advocate of Nigeria, Mr. Norris Quakers, for being here on Newsday and sharing your thoughts on this particular issue.